I ask you, so in my sort of loving parallel, Virginia, in your view, would not have been making a racial classification if they had just reworded their statute to say no person can get a license to marry for the purpose of uniting with another person whose race is inconsistent with their own. I took you to say that the use of the term inconsistent with their sex was drawing a line to prohibit one use of the medication. So why couldn't these statutes have been interpreted as drawing a line to prohibit one use of a marriage license?
Your Honor, we think that in a case like Loving, when you look at the individual level, which we agree with our friends on the other side, that the protection of the Equal Protection Clause operates at the individual level, that if there is a line that is being drawn based off of race, like in Loving, where you had a white male who could not marry an African-American female under that law, that is a race-based line. You are creating multiple groups of permissible and impermissible behavior based off of race. Where we differ from our friends on the other side is we just don't think that there is any sex-based line in this.
But I don't understand why not. I mean, the law here operates in the same way. The question of can you marry this other person depended upon what your race was. You could marry the other person if it was the same, consistent with your race. You couldn't if you couldn't. I take your law to be doing basically the same thing. You can get these blockers if doing so is consistent with your sex, but not if it's inconsistent. So how are they different?
We think it's different because we think in their use of inconsistent with sex and all of these examples that they have in the briefing, those actually do create separate categories of conduct that is permissible either based on sex or based on race. But in this case, the only way that they can point to a sex-based line is to equate fundamentally different medical treatments. Giving testosterone to a boy with a deficiency is not the same treatment as giving it to a girl who has psychological distress associated with her body. This is not only
what's your basis for saying that? I'm sorry. Is it just because of why they're asking for it, or is there some kind of medical? I took the SG to be saying that it operates on the body in the same way. So what's your basis for saying they're not the same?
I don't think it operates on the body in the same way. Take testosterone. If you give a boy with a deficiency testosterone because he has constitutional delayed puberty, that allows him to go through and develop the reproductive organs associated with being a male. If you give it to a girl, it renders the girl infertile. So we have 8 to 12-year-olds being
I'm sorry.
asked.
I thought your reasons for them being different was that you said they were for different purposes. I'd heard you say at the beginning the reason those two are different is because one wants them to transition and the other wants them for some medical purpose.
Well, to go back to my example in the introduction, I don't think anyone would say using morphine to assist suicide is the same treatment as using morphine to manage pain. It's the same drug, just like it's the same drug here, but they're being used for fundamentally different purposes. They have different effects on the body. And once you take out and recognize medical reality, then there is no argument that our law differentiates between treatments for males and females.